Down second. Your Honorable Gabriel and Young, Your Honorable Daniel S. Crofton, and presiding Your Honorable Mark T. Luther. All persons acting as here and here in Canada, they shall be heard. I say to the United States, the state of. Good morning, everyone. It's I'm Judge Boonstra. I'm honored to be here with my colleagues and welcome them to West Michigan, Judge Korobkin and Judge Young, and welcome to you to the Court of Appeals. We are looking forward to your arguments today. Before we begin, let me just, as always, give you a couple of ground rules, especially for those of you who aren't here regularly. Please be assured that we know your cases very well. We've been studying them for some time. We're very well versed both in the facts of your cases and in the legal issues that are presented. I think you'll find that as we go forward. So please bear that in mind. You don't really need to start at the beginning. You can kind of just cut to the chase and focus in on the principal issues as you see them and why you believe you should prevail. We do have some cases involving minors. If you have a case involving a minor child or a victim of a crime, a protected person, please be sure to use their initials rather than their names, as these proceedings will be broadcast on YouTube and we want to protect their privacy interests. So with that, let's begin with item number 1 on today's docket. Case number 376028, People versus Michael Sean Moriarty. Hope I pronounced that correctly. Good morning. Please, yes. We need you to be behind the mic so we can pick it up.
You know, I talked to the prosecuting attorney representative today, and I'm not going to put forth any additional argument and other than what's in the brief. I'm here for any questions you may have, and I think it's pretty clear cut. I know it's Phil sledding on this issue, but I think there may be some teeth in it for you fine folks to look at.
I guess I have one question for you. Maybe just expound on what you said in your brief. You referred to the person who was hit with the motorcycle as you referred to the choices he made as the intervening cause or part of the intervening cause as you see it. I guess I'm not clear what you mean by that. What were the choices that he made that you're referring to?
Your Honor, having grown up in the area, I know that area very well. First of all, it's a dark country county road with no ambient light, no light whatsoever in that area. He chose to wear all black, no reflective devices, no anything, black helmet, black shirt, black pants. And then, Your Honor, another choice he made was when the motorcycle broke down or had mechanical problems, instead of getting off onto the shoulder of the roadway, which it has a very nice improved shoulder, very wide in that area, he chose to work on the motorcycle on the pavement. The evidence came out that they knew that because of the puddle of fluid that it had leaked on the improved portion of the roadway versus the shoulder. And then, Your Honor, another choice he made is once he started moving it, and he was moving it by either straddling it or walking it like this. Again, not off the approved portion of the roadway, the travel portion, not on the shoulder, but on the portion of the roadway where the traffic travels.
On the edge of the road though, right? I mean, it was not in the middle of the road.
Not on the middle of the road, but in the improved portion in the lane of travel.
Okay.
And my understanding of the law is when you're not operating and you're pushing or walking, you're supposed to be going against the traffic and not with the traffic. On top of that, Your Honor, he himself had consumed alcohol, methamphetamine, and THC. And we presented an expert that would show with the levels that he had in his system, that his judgment would have been impaired, would have been erratic, would have not been thinking straightly, if you will. So
That's something the jury had before to consider.
the jury did have that, Your Honor. The jury did. And those were the things that he chose to do. He chose to push his motorcycle in the lane of traffic versus a nice, I think there was a 15-foot shoulder, not a big ditch, flat, and with no reflective devices. And the other expert, a renowned expert and who was employed by Michigan State Police, Mr. Campbell, testified that it was unavoidable. By the time the lights would have hit and reflected back, if you take alcohol out of the equation, it was an unavoidable accident. The evidence showed from the black box that there was no speeding, that there was no erratic driving. And that's why we believe that the feasible instruction was appropriate.
Did one expert or both experts say if you took the alcohol out of the situation, it was inevitable?
When you say that, are you talking about the state's expert as well
Right.
as ours?
Yeah, there were two accident reconstructionists, right?
Yep, and my expert had trained their expert. Yes, I believe, and I don't know if that question was ever
Yes
asked.
to what? Yes to that. They both said this was inevitable.
Your Honor, I don't know if that question was ever asked to the state's expert. I don't recall if that was asked.
Okay.
But there's formulas and how fast light reflects and all that, and because there were no reflective devices, the expert thought that once my client's headlights hit and reflected back to him, it was unavoidable from a braking standpoint.
Don't we need to defer to the jury's assessment of that, however? I mean, that was all presented to the jury.
Absolutely, and that's why I know this is like I said, uphill sledding. I would like to point out to your honors that I was a prosecutor and I've been a defense attorney now almost 30 years. And I've never had as much time as the Honorable Judge Brickley, who I find to be very competent over in Van Buren County, took with myself and Rachel Keeney, the assistant prosecuting attorney, to try this case, to fashion that last prong of the jury instruction that had to do with feasible, the reasonableness, the gross negligence, the proximate and factual cause. And that took us multiple tries and half a day to get it right. And the jury, it just seemed like didn't just completely disregarded that. There's no way they could have took the time and fit the facts into that. I think they just heard that my client was under the influence and that he hit somebody, and that was that. I don't think they applied feasible at all. And the judge went to great lengths to fashion that jury instruction. I attached it. I don't know if you saw it.
But you think the jury instruction itself was correct? Your position is simply that the jury didn't heed it?
They didn't get it or they didn't read it. But I do believe the jury instruction was correct, Your Honor. That's the answer, yes.
Okay, and the basis for you thinking that they didn't read it or understand it is the amount of time it took them to reach the verdict, which was not a lot of time?
That and the evidence was overwhelming that this man, and the judge had to make pretrial rulings. The deceased was grossly negligent. That's how we got to the feasible instruction, that walking at night with no reflective and all black clothes in the travel portion of the roadway, that's how the judge allowed me to get that instruction. Then I think the only thing was it foreseeable that my client should have expected that?
So that's sort of your great weight of the evidence argument, right?
Yes,
Is that
Your Honor.
is that the evidence was so overwhelming that the jury made a mistake?
Yes, Your Honor.
Thought I read somewhere in the record that he had reflective Nike shoes. Am I wrong on that?
On the sides. And he's walking away from my guy coming at him. So that if you were on the side of him, you may have been able to see the swoosh or something, but not from behind.
All right. Thank you. Any further questions?
Okay.
Thank you very
Thank
much.
you very much.
Thank you.
Response?
Thank you. Good morning. Paige Petrosky on behalf of the people. I'm also going to keep things pretty brief and rely on the briefing, but as Your Honor noted, the victim did have reflective material on his shoes. He also kept the rear lights of his motorcycle on while he was transporting it home. And he also kept his helmet on, and he was less than a quarter mile from his home. He was to the side of the roadway. And all of these things show actual attempts at mitigating potential risk, which just gets rid of the possibility that he was acting grossly negligently. Judge Brickley did not, in deciding to allow evidence of the victim's potential intoxication or the substances in his system, the judge did not decide that the victim was grossly negligent. Judge Brickley ruled that the evidence of intoxication, at the very least, raised a potential jury question of negligence, not gross negligence. And so because it raised a potential question, she felt that it was most prudent to allow the fullest possible picture for the jury to then use the agreed upon proximate cause instruction to then evaluate that evidence and determine whether or not proximate cause existed. And so that was what the determination on the victim's intoxication from prior to trial, what that was actually referring to. And then the only other factual point that I want to touch on, I don't remember if it was both experts who had said that it was unavoidable, but my recollection of the record is that the crash was unavoidable because he impacted the victim when he was going 54.7. There was no initiation of any brake. I believe that the questioning was more along the lines of if he had stopped at that, or at what point would he have had to have stopped? And essentially their expert assumed or came to the conclusion it was unavoidable. But that wasn't in relation to visibility. That was, I believe, in relation to the speed at which he was going. And so if there are any, unless there are any other questions, I will rely on the briefing.
Questions? Thank you very much.
Thank you.
Any rebuttal?
Again, I'm not 100% certain, but I think the testimony wasn't that the lights were on, Your Honors. The testimony was that the lights were in working order. But when you're pushing something, you typically don't have your lights on. And the reflective devices, again, on his shoes were not devices. They were shoes you buy over the counter. And the side had the swooshes on, not the heel. And it is a matter of visibility. There was lots of testimony regarding reflection and how fast one would have to be going or slow for the lights to reflect off the victim or an object, come back and give the person time to hit the brakes. Thank you very much.
Thank you both very much. Appreciate your arguments. That case is submitted. Moving to item number 2, case number 374635, People versus Stephen Michael Brooks. Ms. Petrosky can stay where she is, and we have appellant's counsel appearing remotely, I believe.
Okay, judges, I think I'm with you now.
Good morning, Mr. Branch.
Yes, William F. Branch, attorney for the defendant appellant. Now, in this case, Judge, I'm going to defer from what I usually do and just say that I think the arguments are best served here by the briefs rather than trying to simply reiterate what's in the briefs. I'll stand on the brief in this situation, just reminding the court that this was a bench trial. Therefore, the clearly erroneous standard applies to the lower court's finding of facts. And when that is the situation, one of the standards is although a finding of fact by a court sitting without a jury is clearly erroneous, where although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. So that's a little bit a different view than we usually have on the jury trials. But other than that, judges, I reviewed these and I don't have anything to add to the briefs that's not in there. And the briefs kind of, although short, are complex due to the references to the video. So I have nothing more to say on them except to be available for questions.
All right, thank you, counsel. Any questions?
No questions.
I see none at this time, but you'll have time for rebuttal.
Okay.
Ms. Petrosky?
Paige Petrosky on behalf of the people. I will also be relying on the briefing unless there are any questions.
So I guess on the assault conviction, the domestic violence conviction, um, there's the testimony of the officer that he saw Mr. Brooks push his sister. Is that the gist of the evidence that there is?
Yes, that was the people's, I guess, theory of the case was in line with what the officer had testified to. And also what the neighbor, I apologize, I know it's a compound name, but what the neighbor had also, she didn't test or didn't see the specifics of how the assault happened, but did see the defendant's sister fall backwards. So those were the 2 points of evidence that were the primary part of the people's case.
And then I
But-
think the other evidence, the conflicting evidence, I don't know, maybe conflicting is the wrong word. The other evidence is that at that moment, I think the sister said he didn't hit me or something like that. And then the defendant himself testified, she was upset. I was trying to give her a hug and she didn't want that. So she kind of pushed me away. What are we to make of? I mean, that could be a misinterpretation of what the officer Gibbs saw.
Yes. So with that, I would note that any or most kinds of touching, or even like something like a hug, a friendly touch, the context and the consent for that touch is what distinguishes that from being a welcome, invited, friendly touching from an unwanted or an offensive touching. And the sister and defendant both basically testified that they were upset, they were arguing with each other. Other witnesses also testified to the contentious nature of how things were going. And then they both were pretty much in agreement that he went in to try to hug her. She understood he was trying to hug her. And then she said something to the effect of, get the F away from me. And so at that point, she is not consenting to that touching. That is an unwanted, offensive touching in that context. And so even from the record established by their testimony, trying to state that this was not an assault, at the bare minimum, that is an assault. She put her in immediate fear of an unwanted or offensive touching. So even under either theory, either the people's or defendant's testimony and his stated theory of the case, both constitute domestic violence. Well, thank you very much for your time.
Thank you.
Thank you.
Mr. Branch?
No, I don't have any response to that except to say I agree with what the court said and what Ms. Petrosky said.
All right. Thank you both. That case will be submitted. And Mr. Branch, you can stay right there. We're going to move to item number 3, case number 369-335, People versus Mandy Marie Ben. And Mr. Branch, I believe you are the only endorsed party on this case.
Yes, it seems that way, Judge. Okay, William F. Branch, attorney for the appellant, the defendant appellant. Okay, this one, Judge, as I would like to touch a little bit more on the facts and a response to some of the things raised in the prosecutor's brief. Now, of course, there's no denying that this is a terrible incident. You had good people who were killed and good people who were injured, but we do not believe that these rises to the level of second-degree murder. Question then it comes down to malice. Now, my reading of the transcript was that the prosecutor relied entirely on the prior 2017 incident in which Miss Ben was driving under the influence of the prescription drugs and methamphetamine, and that is the crucial point. The 2017 incident included methamphetamine, which can cause anxiety and paranoia. Now, looking at some of the guidelines that the courts have laid out for us in the past, in Sabin, the Supreme Court said general similarity between the charged and uncharged acts does not by itself establish a plan, scheme, or system. To establish the existence of a common design or plan, the common features must include the existence of a plan rather than a series of similar spontaneous acts. And in Nevin, the courts pointed out that the similarity must be substantial. Now, we both also, the trial judge and both briefs cite this fairly recent case, Werner, People versus Werner, which was also a second-degree murder case. And in that case, the prior incident was about, I think it was 3 weeks before the sentencing incident, and both involved driving while under the influence of alcohol. So what's the difference? Well, the prior incidents in Werner was 3 weeks earlier. Ben's was 5 years earlier. Werner's priors included the same substance, alcohol. Miss Ben's prior included, most importantly, the methamphetamine. Now, why do we keep emphasizing that? Because methamphetamine is a very different drug with different effects than the prescription drugs that was solely involved in the 2022 case. Unlike the prescription drugs, meth is a stimulant, a powerful stimulant, which can cause paranoia. Now, remember when she stopped in the 2017 case, it was because of paranoia. She thought that the truckers were out to get her, that the truckers were trying to kill her. That was not a symptom in the 2022 case. The symptoms in the two cases were different. What she learned in the 2017 case was not to use methamphetamine anymore. There's no common plan, scheme, or system here. There's a general similarity, which Saban warns us is not enough. It also fails, and the second prong of Van der Walle being that it is too far removed in time and manner, 5 years as opposed to the 3 weeks in Werner. We contend it also fails the third prong, that it was more prejudicial than probative. The single incident 5 years later using meth was not substantial as required in Nevin, or I think it's Neves actually. Okay, now that brings us to the sufficiency argument and back to Werner. In Werner, the prior conviction, alcohol, 3 weeks before the sentencing offense was used to satisfy the malice requirement. Miss Ben's prior case should not have been used because it doesn't have those elements that were in Werner. It was 5 years rather than 3 weeks. It added methamphetamine. Without that prior conviction, there's no malice and no conviction for second-degree murder. And here I come to one of the arguments raised by the prosecutor in their brief. They contend that even without the 2017 conviction, they could have shown malice. We don't agree with that. I don't believe the prosecution argued that at trial. Without the 2017 incident, I doubt that the second-degree murder would even have been charged. Now, to others observing her, yes, she showed the affection of prescription drugs, but there's no indication that she recognized them in herself. She had extensive conversations with the police and the hospital staff. Nothing indicated that she believed she was suffering any side effects from drugs. The cases the prosecutor cites in this argument show why malice was not established in Miss Ben's case. Miss Ben had no high-speed driving. She was not fleeing from the police. She didn't run any red lights or stop signs. Nobody warned Miss Ben she was driving unsafe. No passengers jumped out of her car. And these were all elements in the cases cited by the prosecutor that were not present in Miss Ben's case.
Wasn't there evidence, though, in the current case that she was acting erratically, I think, at a gas station before this incident? So
Correct.
Maybe the jury could have inferred that gave her some indication that, hey, these substances that you've taken, they're no good.
But there's no indication in this case that she realized herself that she was acting erratically. None of the clerks at the gas station said anything to her about it. And that's an interesting difference between her case and the ones cited by the prosecutor. One of them cited by the prosecutor, people told the driver, hey, you can't drive. Other ones, passengers jumped out of the car. We don't have this in Miss Ben's case. Yes, to the clerk, could see she was acting erratically, but there was no indication that Miss Ben herself realized that she was acting erratically. So that's an important distinction to draw there. Now, I think drawing to the end of the points I wanted to bring up, the prosecution brings up the Kowalski case and argues that the trial attorney waived any appellate review when he did not file, or at least we pointed out, he did not file any objection or present any oral argument to admitting the prior acts. What he did say, he said he would leave it to the court's discretion. Well, that's a given. Of course, he's going to leave it to the court's discretion. He said that before the ruling. He doesn't express satisfaction with the court's ruling. He was silent. In Kowalski, after the ruling was made, the defense attorney expressed satisfaction with it. That didn't happen in this case. Now, what he did do in our case is nothing. He didn't say anything one way or the other, which is why we argued he was ineffective for failing to object. But we don't agree that the error was waived. Well, and then the last thing I think, or one of the last things I wanted to talk about, I'm way over how long I usually talk, but this is a very important situation. The curative instruction. Okay, the curative instruction simply advised the jury that the prior incident could show plan or scheme, but our argument is, as a matter of law, the incident did not show a plan or scheme. Therefore, the curative instruction should never have had to been given. It simply notified the jury that they could find a plan or scheme when they never really should have been advised of the situation in the first place. That's all I have to say on this, judges. I think obviously this is a very important case. You have very important to the victims, terrible situation, very important to Miss Ben, who is in all likelihood, no doubt, serving the rest of her life in prison. We addressed that issue also, but it's covered in the brief. With that, that's what I have to say this morning. Available for questions, of course.
Thank you. Any further questions?
Well, I guess I do have some questions about the consecutive sentencing, and
Okay.
Truth be told, I'd probably be directing these to the other side if they were here. But let's suppose that we are not persuaded by your argument on the conviction, and we move on to the sentencing issue. What is the appropriate remedy for an unexplained consecutive sentence? In other words, if we just don't know why the trial judge decided to make these two sentences consecutive, what's supposed to happen at that point?
Well, I think it would be the same as if he had not, the judge had not explained why he exceeded guidelines. It would be to remand it for resentencing, and resentencing, if that's all you did, to remand it, you'd have to remand it for the judge to make a statement just as if he had exceeded the guidelines, right? That's what we usually do on those cases, is refer them back. But at that resentencing, all arguments are open.
Yeah, I guess what I'm getting at, and I think what you're starting to get at too, is, you know, if we do that, does everyone have to come back and do all of the sentencing stuff all over again, victim impact statements, all of that? I mean, that's a lot to do. Of course, if that's what needs to happen, that's what needs to happen. But I'm struggling a little bit with what's supposed to happen when we just don't really have the explanation we need about consecutive sentencing.
Well, I don't think we need to redo victim impact statements, etc. But my understanding of the way resentencings typically work is that if we find some error, we can bring it up even if it was not brought up in the prior sentencing. But I don't think anything has to be redone. I think the pre-sentence report would have to be redone due to the passage of time.
All right, well, something to think about.
All right. Thank you very much, Mr. Branch. We appreciate you being with us remotely. And,
Okay.
and that case is submitted.
Okay, thank you very much, judges.
Have a great day.
You too. Bye-bye.
Moving to item number 4 on our docket, case number 369123, People versus Robert Lee Simons. Appellant's counsel appearing remotely as the only endorsed party.
And I'm muting. Okay, am I there, guys?
Good morning, Mr. Strauss. You may put your appearance on the record and proceed.
Hi, Gary Strauss on behalf of Mr. Simons, 48673. Should I proceed?
Yes, please.
Yeah, we believe, and obviously, the court has read the brief, is well versed in the brief. I think this is squarely within Thorpe, where the case was reversed and remanded because of Mr. Cottrell. Been many cases with him. He has a penchant for doing that. In Thorpe, I think he mentioned a couple incidents, and basically was tantamount to testifying that children never lie in these credibility contests. In our case, it's even more egregious. The court kept expounding, asking him. He said it rarely happens, and could you give us an example of cases that you've had where a child was fabricating? Then he gave 5 examples. None of them were remotely similar to our case. And then the judge even asked, do you have any more? And he said, no, just the ones I mentioned. That's where fabrication took place, essentially saying 0%. And I think they made clear in Thorpe that he doesn't have to give her a percentage, but it was tantamount to doing that. Ruiz was different, and the prosecutor, I believe, hung their hat on. In that case, it was just one fleeting comment. And I would add, I'm sure your honors are probably aware of this, in a recent case of People versus Bonner. The Supreme Court granted the application in Bonner, again, that dealt with Mr. Cottrell, dealing with a lot of the issues we have here. And one of the things they want people to brief there, oral argument has not occurred there yet, was whether the expert testimony requires reversal of the defendant's convictions. And I'm not sure if the court takes things in abeyance to wait on the Bonner decision by the Supreme Court. But as in Thorpe, I think our case, it really weighs heavy. They talked about in Thorpe that in the credibility contest, where this certainly was, that an expert weighs pretty heavily. I mean, the jurors aren't aware of Cottrell's track record. They're looking at him as an expert. And he basically told them, it never happens. And I won't go into the second argument in any depth, but I believe that character evidence, bringing that up, does not open the door to 404B evidence that would not otherwise come in. I'm sure the court will consider that as well. But we would ask that
Mr.
this
Strauss,
case. Yes.
Mr. Strauss, you cite Thorpe and Bonner. And in between both of those cases is a published case from this court, People v. Sattler Van Wagner, which is nearly identical to the case that you bring before this court, but it wasn't cited by you or the prosecutor. And in that case, our court says exactly what you say today, which is our Supreme Court's analysis in Thorpe was not limited to specific numeral values. It applied more broadly to the odds or likelihood that someone is telling the truth.
Mm.
So I just bring that to your attention because Bonner, I don't think we would obey for Bonner anyway, but we also have binding case law that that more or less makes the argument you present to this court today.
Well, thank you, Your Honor. I'm remiss on not keeping up to date on these things, but yeah, it was kind of egregious. And I thought it was kind of wild when the judge kept listing this information, and it's no secret, that Cottrell is falling into this trap before.
I did want to ask you about the circumstances of that. I was having difficulty navigating whether this issue was waived or forfeited, because it seemed like, according to the notes we got in the file, the trial court and the parties were presented with the juror questions and kind of gave them a thumbs up or thumbs down. Unfortunately, that bench conference was not transcribed. And so there's just notes from, I believe, the judge themselves, just saying whether an objection was made or not. Here, there's no indication an objection was made, and there's no indication an objection was not made. Both of those notes are included throughout. So but because of the circumstances of the question coming out, it felt like this had a waiver risk. Can you tell me why this is forfeiture and not waiver? Or
I
maybe it's
really-
preserved, but I definitely don't see preservation on this record.
Yeah, I believe here, and I'm not prepared to really answer in depth that question, to be frank with the court, but no matter what standard of review is used on this, I mean, the judge brought out this information. I don't know if he would have objected to the judge, and the jury heard it. You know, they heard it all, and I mean, that was so prejudicial, and exactly what made the Thorpe court reverse the case. So it's out there. I mean, there's a reality. It's not apparent what happened in the sidebar, but the reality is that he was not given a fair trial, and that he violated his rights, like the court did. He was in on it, maybe inadvertently. So the bottom line, at least in my mind, without getting into technicalities, not technicalities, I wouldn't say, since that's the law, but it wasn't a fair trial. I think it requires reversal.
And you argued ineffective assistance of counsel in the alternative?
Yeah, yes. So either way, if that makes the standard even higher, I think we could we could jump over any hurdle in that regard, Your Honors.
So, Mr. Strauss, let me just follow up on one point, and you may not yet be familiar with the case that Judge Young referenced, the Sattler-Van Wagner case, but it did hold that very similar testimony to Mr. Cottrell's in this case, that it was error to admit that, and we're bound by that. But that court, and I understand you don't know the facts of that case, and I don't remember them off the top of my head either, but that court nonetheless affirmed, because they found that the error was not outcome determinative. And I think you've touched on this a little bit, but could you talk a little bit more about what the overall parameters of the evidence was here, and why you believe this error was outcome determinative in this case?
Well, I'm probably just reiterating what I'd said before, Your Honor, but you know, in a credibility contest, you know, of this nature, to have the judge asking questions and then Thorpe responding, essentially saying that children never lie. I mean, that kind of sums up everything right there. No matter what else happened, you know.
So was there any countervailing evidence other than the complainant's own testimony? Is that what you're saying? It was a pure credibility contest?
I believe so, and then it is, yes. He asserted his innocence, and they had to prove their case, and certainly didn't. And even if there obviously there's some evidence, because NN testified, but Thorpe was the wind beneath the wings, I would say. You know, I mean, he's an expert, and Thorpe did comment on that specifically on that situation. You know, I have the quote here, but I'm sure the court's aware of it. But the Thorpe case did say, to a jury recognizing the awesome dilemma of who to believe, an expert would often represent the only seemingly objective source, offering it a much sought after hook on which to hang its hat. And I think, but that's really the argument in the end. It wasn't some fleeting thing, you know, or it could have been either way. I don't think that can be permitted. I think the courts have said that before, and I think in the I believe the lower court in the case that's up before the Supreme Court in Bonner, I think that was basically the same situation or similar situation.
Any further questions? Anything else, Mr. Strauss?
No, no, Your Honor.
All right. Thank you very much. I appreciate your arguments. That case is submitted. And Mr. Strauss, you can stay right there, because we're going to move to item number 5, case number 370533, People versus Nicholas Gray Williams. Again, Mr. Strauss is appearing remotely for the appellant as the only endorsed party. You may proceed.
Yeah, I really have nothing in this case to add, Your Honor, in addition to the brief.
I have one question for you.
Mhm.
With regard to the sentence in this case, the, there was a home invasion conviction, assault with intent to do great bodily harm, and a felonious assault, I believe, correct?
Mhm.
The guidelines on the felonious assault were 10 to 23 months, and the sentence appears to have been 84 days. I wonder if you can maybe, you have any thoughts on why that happened or whether that was a mistake or intentional?
No, I don't.
All right.
But it goes to our benefit, so I won't say a
It does.
thing.
It does. All right. Any questions for Mr. Strauss?
No.
All right. Thank you very much
Oh, thank you.
for being with us remotely, and that case is submitted.
Okay, appreciate it. Thank you.
We're going to move to item number 6, case number 374198, People versus Desmond, Dwayne Mark LaFleur.
I please the court. My name is Robert Wellman. I'm representing the appellant, Desmond LaFleur. I'm not going to rehash every single point in my brief, but I would like to summarize it over more scrutiny for your understanding. So the first question that I raised primarily was if we're going to apply Drake to this jury trial, we find that it is applicable. I don't believe that circumstance, it may be important for the trial attorney to call the witness on whether or not there was really skin-to-skin contact, whether or not she was really able to, go through all the clothing, if there was a hole in the underwear, if there was a hole in the jumpsuit. Primarily because we're talking about over perceivable, whether or not that's, again, I think a lot of these things, and Drake doesn't really even talk about masturbation, but if we are applying that because we think it's applicable, the open and perceivable part of it may be relevant as far as calling this witness that said that he only investigated him for contraband, for drugs, and not because he thought there was this indecent exposure or gross indecent exposure that occurred. Now,
I'm
the
sorry.
main point,
Counsel, I'm trying to follow you're saying Drake, People versus Drake
correct.
is your case? This is the case that you think this would be supportive of your appeal for? I'm having trouble understanding why that is.
No, I'm not saying, I don't
Okay.
agree that Drake should be applied to this.
Oh, okay, all right,
So
all
what I'm
right.
saying is if the court does find it to apply to this case,
Yeah.
that's what the trial court did. They applied that rule.
And the reason you don't think it should be applied is because Drake involved minors and this case doesn't?
That would be one factual distinction.
Okay, can you tell me any of the others?
Well, in Drake, this was an act that was done in the privacy of his home. And so they were trying to get into whether or not this would be gross indecent exposure based on him not actually doing any of the prescribed act under the criminal jury instruction. So that would be either sexual penetration, anal penetration, oral copulation, and masturbation. That's it. This didn't fit any of those. And so what they were trying to do is, based on what he was doing with these minors, would that be, and again, they came up with that standard, open and perceivable, because I think they were trying to figure out, and I think counsel suggested that the open and perceivable meant the sexual gratification part of it was perceivable. That wasn't clear, but I don't think it should be applied because, again, they were minors. That alone can make it indecent exposure, gross indecency. And then the fact that the act that were alleged here doesn't fit anything. It's not masturbation at all. It seems like it shouldn't be applied. I think Drake, whatever the holding was, should be very limited to just that type of situation. Going on to the second question presented, the second question that I've argued here, I think this is the most compelling part of this brief. Is that there's been a lot of effort up until today to prescribe these acts that would constitute gross indecency, not just the circumstances that would make it gross indecency, but the acts themselves, because the legislature didn't do that. And so we were kind of left with the jury instruction, which came up with people with Barno, but they did prescribe certain acts. And if you look at that, one of the problems with this case is that my client didn't do any of those acts. And we're talking about masturbation, it says very clearly, and people with Barno held it, masturbation of yourself or of another person. He didn't do any masturbation. He didn't masturbate the other person. It was being done to him, but he didn't commit that act. Reading the brief from the people here, suggesting that we're supposed to come up with a new class of mens rea, the kind of where you have something done to you, and if you consent to it, then you're guilty. Well, what is that? Because the act that he committed. Did he just, I guess by analogy, if you were witnessing somebody commit a crime, break into a building, and afterwards, after it's done, you laugh about it. Are you guilty of, helping them out? Well, it's not aiding and abetting. What are you guilty of if you stood by and let it happen, didn't report it, then laughed about it even? Maybe you took pleasure in it.
Of course, the statute is satisfied if he is found to be a party to the commission of an act of gross indecency. So what you're essentially saying is that someone committed an act of masturbation on him and he was not a party to that act. Is that what your argument is?
Yes. And I would also argue that if we start prescribing that to be what a party means, first of all, the statute doesn't define that. We have no case law that defines what a party means, if it's anything other than aiding and abetting. We don't have that description. I think if we're going to go along with the state's argument that's what it means, if you're letting something sexual being done to you, we haven't prescribed that before. And I think if we apply it that way, it would become unconstitutionally vague. But I don't think that's what the trial court did necessarily. I think they just went with the Drake holding and argued that it was gross indecency that way.
Is the Bellamy Creek visiting room private or public, and does it matter?
Can you repeat that? I'm sorry.
Is the Bellamy Creek visiting room public or private, and does it matter?
If I understood you, why does Drake not matter? Why did I believe it?
No. Is the prison visiting room, is it a public place or a private place? And does that matter?
Well, so I would argue that that standard being a public place wasn't also met. Well, one, if you believe the trial court applied the right law, it was whatever was open and perceivable. I would argue that it wasn't open and perceivable. I know that there's a more common understanding is that they're likely to have perceived it or something of that sort. Because there were some cases where it was involved in a privacy of somebody's home, and they did find that standard, they're likely to see that. But my argument here again is there was a lot of effort to conceal what was going on. You wouldn't have been able to tell at first glance. I've watched that video myself, and you had to pay attention to what they were describing in testimony, and then you could start seeing movement. But other than that, it wasn't very obvious. So I would argue it wasn't necessarily done in a public place within that meeting. But I just go back. The main point here is, have we actually found prescribed gross indecency in a way that everybody in the public would know? Or are we going to go along with this argument and make or draft a new type of act or mens rea, where you just stand by and let it happen to you? You don't, and as long as you consent to it, you're a party to it. I think that would be very problematic. And then finally, my last question, and this relates to the not the directed verdict, but at the end, ultimately finding the fact. My argument, just to summarize, I don't think Blake should have applied at all. We should have been applying Howell or generally the jury instruction. So what I mean by that is there are prescribed acts under that jury instruction. And why are we doing that? Well, the legislature didn't do it, so we gotta do it. It's constitutional, and it's what we need to do. When you charge somebody find guilty of crime, they have to have adequate notice of what it would be to commit a crime, and that's what Howell does. That's what those jury instructions reflect. People versus Bono added masturbation to that list. But if we go with just that and what's been prescribed, what we found to be adequate notice, what my client did, again, didn't meet any of the prescribed acts. So we can go on a long time about the circumstances, the prison, the being in a public place, all those. I think we still fail the very first element. What is the prescribed act that my client did? And I don't think we have any proof of that. That was the summary of my third question, my third argument. I'd be happy to take any more questions if they.
Questions? Thank you very much. You do have time for rebuttal. Let's hear from the other side.
Good morning, Your Honors. May it please the court, Autumn Wilmot on behalf of the people. I believe my brief fairly addresses all of his concerns that were made. I would note that I do think that the visiting room is open to the public. There were, if I believe correctly, about 11 other people in the room. And the guard that was on the camera that could see them testified that she believed what they were doing was that the girlfriend was giving him a hand job.
I agree that there were other people present when something that fits the statutory definition of indecency occurred. My question though is, what do we do with the fact that a prison visiting room is not itself something where the public is welcome? The individuals in that room could not like freely enter and exit. It's not a place where the public is generally invited or allowed to be. Members of the public were present, but they had to go through a lot to get there. It's not quite as private as a house, but there are substantial barriers to the public entering that room. Some members of the public surpass that barrier, and is that alone enough? Just that some members of the public can meet all the criteria to be in this room?
I think it's interesting that the statute basically says that it's open to the public, not that there's no differentiating between can we just freely come and go like the Meijer or the Walmart, or is it you have to go through these hurdles? The public is still the public. These are still members. These weren't just people in prison. These were people from the public that jumped through those hoops.
I think if someone asked, is a prison open to the public? The answer would be no.
I think that if the answer was no, then they wouldn't have any visitors because the visitors are still the public.
So if any member of the public is present in an institution, that institution becomes a public place.
I think in that room at that time, because the public through those visitors had been invited, that room at that time was open to the public.
Okay.
All right.
There are no other questions. I'd ask this court to affirm.
All right. Thank you very much.
Thank you, Your Honors.
Any rebuttal? All right. Thank you both for being here. Case is submitted. We'll move on to item number 7. Case number 376473, Abby Postlethwaite versus Storage Group LLC.
Good morning, Matthew Swartz for the plaintiff appellant.
Morning.
I would reserve 5 minutes for rebuttal. I do not think it is going to be necessary here. As a running theme today, I'm going to rely primarily on the briefs in this case. The issue decided by the trial court ultimately was very narrow. There were multiple issues certainly briefed in the trial court, but the court decided the issue solely on the issue of duty. Was there a legal duty owed under the circumstances? I'm certainly prepared to talk about the remaining issues that were briefed and argued in the trial court. But I'll defer on that unless the court has any questions about that or is deciding to affirm on one of those bases. The issue of duty is really governed by 4 cases, Grimes and Parsons, which are older Michigan Supreme Court cases, which essentially lay out the general duty or the general standard that governs the situation. These are kind of strange cases. The case law sort of uses premises liability language, but these are not strictly premises liability cases. The distinctions of trespasser invitee, licensee are not really relevant here. This is kind of a unique duty under Michigan law, which is essentially what the Parsons and Grimes cases sort of lay out, which is essentially the duty of a premises possessor to use ordinary care to people on abutting or adjoining public ways, whether it be roads, sidewalks, et cetera. So those cases lay out the general duty, and that general duty does exist. That duty was kind of expanded and refined by subsequent Court of Appeals cases, those cases being the Stevens case and the Berman case, which Berman was 1969 and Stevens was 1989. Berman really does a better job of sort of laying out the duty. Stevens more or less relies on Berman for its holding. And Berman, at the very closing of that opinion, this is page 58 through 59 of that opinion, essentially lays out, I guess, the expanded or refined duties that a premises owner owes. And those are as follows. Essentially, there is a duty on abutting publicly owned property, sidewalk, roads, what have you. If there's three, only two apply here. If, number one, the defendant increased the hazards in the parking area, or in this case, the public way, increased the hazards of the public way, which existed at the time of the injury, or created new hazards on the land strip. So essentially, this is a sort of disjunctive test. The two situations that I referenced there, and also the situations that Grimes and Parsons dealt with, which are essentially something on something on private land extending over into public land. We don't have that here, admittedly. So the question is whether one of these two situations outlined by the Berman case, again, as sort of approved by the Stevens case, applies. And essentially, we say that it does, in so far as there was essentially a blind corner created by this fence and the political signs or the signs on the fence.
Wasn't it really created by the city or township or whoever it was that narrowed the sidewalks in that area? I mean, the fence was always there.
The fence was always there. The sidewalk was narrowed by the city. We do not dispute that. The question is whether the defendant's fence, or really more specifically, the obstructions on that fence, again, as stated in Berman, whether that situation increased the hazard of the narrowed sidewalk or created new hazards. And so the question is whether the fence, I understand the fence was already there, but if we assume the testimony of the plaintiff is true, there was essentially a blind corner which was created by the defendant. The signs on the fence definitely were put there by the defendant. This is not public property. They either assented to that or put those signs up themselves. And so if the only issue was the narrowing of the sidewalk in the absence of the fence or the obstructions on the fence, I think Your Honor would be exactly right. They would not have created that, altered that, added to that in any way. But I think because of the fence being there so close to the property line, added to the obstruction, I think that's where we fall more into the Berman case, where, as distinguished from the Stevens case, there was something done by the defendant. Because in Stevens, essentially what happened in that case was there was a tree in a berm, which was in a right of way on public property. The court distinguished that case and said there was no duty in that Stevens case because the defendants in that case didn't fertilize, maintain, do anything to the tree. Okay, the tree was there on public property. They didn't do anything to that. Because of that, it did not fall into one of the situations addressed by the Berman case. And I think the case here is distinguishable because there was something done in this case to make this fence and this sidewalk more dangerous by the defendant. Again, namely the political signs creating kind of a blind corner there. Which
I was never clear on why that obstruction caused this particular accident. I mean, if the plaintiff had, gotten hit by a car and then said, I couldn't see around the corner, that would be a different situation. I'm not clear what was it about the signs or the obstruction that caused this injury?
Essentially, the plaintiff's testimony was because of the obstruction, she couldn't see what was on the other side. And so rather than, I guess, taking the fence at a bit wider berth, she had to hug the fence closer because she was afraid of being hit by a car or running into the road, things like that. So that was the testimony from Ms. Postlethwaite during her deposition. Certainly, I can concede that there's probably a fabric of causative factors here, but I think the obstruction was one of them insofar as because she couldn't have, because she was kind of afraid of going into the road, didn't know what was on the other side, et cetera, that caused her to hug the corner more closely than maybe she otherwise would.
So if the obstruction wasn't, if the signs weren't there and she, I don't know, it's like a chain link fence and she could just see through it. How would that have gone differently?
I guess the inference there, Your Honor, there's no direct testimony on that, but the inference there would be if she could see specifically where the sidewalk was on the other side. No, there wasn't a car coming, encroaching on that, or that she could exactly know where she's going to be. She would have taken maybe a different approach around the fence.
There wasn't room to take a different approach, was there? It was so narrow and her handlebars are as wide as they are. Wouldn't she have hit the fence anyway?
I think that's probably a factual question. Again, that kind of goes to the point of if she maybe had a better idea of what was on the other side of that fence, she would have positioned her right handlebar to be maybe more into the roadway going around the fence than she otherwise would have. I guess.
Didn't she actually testify that she saw there were two vehicles on Pontaluna Road?
She saw there was a Jeep turning right in front of her. That's correct. She saw partial or she couldn't remember exactly if she saw a vehicle behind that vehicle. So she did see a vehicle directly in front of her, which was turning.
So, I mean, I appreciate there was some level of obstruction there, but I'm not sure it's fair to say it was a blind corner. She knew there was something there and she could see in front of her. There was a very narrow sidewalk going around the corner.
Well, that's, I guess the question, Your Honor, is whether she certainly could see right in front of her at the corner how wide that sidewalk was. I guess the point is she couldn't see what was on the other side of that corner to determine maybe the best course of action relative to traffic or relative to how to navigate that corner. I certainly understand what Your Honor is saying. She could definitely see in front of her. She could see up to where that vehicle was. I guess our biggest point is she couldn't quite know what was on the other side of that, and that I think caused her to kind of do what she did.
Any further questions or anything else, counsel?
Okay, thank you.
All right, you have time for rebuttal. Response?
Morning, Your Honors. Matt Simons here for the defendant. I just wanted to address and pick up on the blind corner notion. I think it's important, and we did reference it in our brief, Ms. Postal-Waite's own testimony relative to what her intentions were. Irregardless of what obstruction may have been presented by this fence, her intention was to turn exactly where she was trying to turn. She testified at her deposition, regurgitated all, but it's at page 36, 39, and 46, that she was going to turn there because the school that she was going to visit was on that side of the road, the south side of Pontaluna, required her to turn left at that corner. Judge Boonstra's question earlier, Ms. Postal-Waite did testify to having seen two cars at Pontaluna with the intention of turning right. So she knew there was an intersection there that she had to turn at, that she was already planning on turning at anyway. It's our position, Your Honor, that the duty that my client may have owed did not extend beyond purview of the envelope of its property. And the cases that Mr. Swartz cited, I believe, are on point, supporting trial courts granting of our summary disposition motion. Grimes, Parsons, Stevens, and Berman. I will not reiterate everything that was said in those holdings, and I'm happy to answer any questions the panel may have.
Questions? I see none. Thank you very much.
Appreciate you.
Thank you.
Any rebuttal?
Unless the court has any further questions for me,
I don't have any. Thank you.
I think we're good. Thank you both for being here. Appreciate your arguments. That case is submitted.
I'm good with whatever.
Keep going.
All right, we're gonna plow forward into our 11 o'clock call. I think it's 11 o'clock or it is after 11 o'clock. So we're gonna move on. Before we do, let me just reiterate, I know there's some folks who weren't here when we began. As you can probably tell, we are very well versed in your cases. We know the cases factually and the legal issues presented. So just please keep that in mind when you present your arguments. You don't have to start at the beginning of the story. We kind of know where it starts, and you can just hone right in on the key issues from your perspective and why you believe you should prevail. So let's move right on to item number 8, case number 375668, James Peterson versus Spring Lake Township. Believe we have one party endorsed.
Good morning. May it please the court, Brad Fisher on behalf of the petitioner appellant, James B. Peterson. In addition to those items addressed in the brief, I will note that since the appeal was filed, the KNIER, the KNIER decision cited in the brief that the township relied upon has been vacated and remanded. We did not rely on that in our brief at all, but it was a basis for the tribunal making its decision.
I'm sorry, can you tell me what that case is again? KNIER?
Yeah, KNIER.
Okay, thank you.
In the absence of another party against whom I am arguing, I'm happy to rely on the content of the brief. Does the panel have any other questions for me?
Don't have any.
Just so the KNIER case, you think that makes a difference here or no?
I think it makes a difference because the tribunal relied upon it in saying that it investigated very deeply the nature of the improvements made in that case when it made its decision. Similarly, in this case, the township, in conjunction with its opposition to my client's appeal, specifically on page 43 of the appendices that I've attached, the township had argued that somehow whether or not the repairs and maintenance were necessary was a component of what my client had to prove. And from our perspective, the statute itself does not require that my client prove the repairs were necessary or that the maintenance was necessary. The statute itself, the Matthew Gast Act, looks simply at what is the nature of the improvements or maintenance being made. And if it's simply, if you are repainting is not subject to an increase in the taxable value of your property. And you don't have to ask whether or not the painting was necessary. It's simply what is the nature of the work being done.
So if I recall correctly, the tribunal did not make a determination that these were or were not normal repairs, that they were entitled to exemption, but they essentially held their hat on their position that your client didn't come forward with evidence to support that.
The tribunal,
that?
yes. The tribunal said there wasn't enough evidence to make a determination regarding the true cash value of the property.
Right.
And I think that's a separate issue than whether or not the matters are eligible for not increasing the taxable value under the Matthew Gast Act. You know, his pleadings identified what was the nature of the work performed. And that, according to my client and apparently under the statute, appears to indicate that you shouldn't be increasing the taxable value as a result of the nature of that work. And the tribunal said there isn't enough information here to make a determination regarding the actual value of the property and the separate question between the value of the property and the nature of the work performed. That's where we are trying to differentiate it.
So that was definitely one of the issues, but I think even before they got there, they said that the documentation about who made the renovations, when they were done, what was the nature of the renovations was lacking. And that seemed to be a finding of fact by the tax tribunal. And of course, we're not totally bound by that, but if the, you know, our standard of review over findings of fact are fairly different. So.
Yes, understood.
Is there anything you want to address about the nature of the evidence that was presented to the tax tribunal?
Beyond what was cited in the brief, no.
Okay. All right. Okay. Thank you.
Okay.
All right.
Anything further?
Just request that the MTT decision be reversed and the respondent reduce the subject property's taxable value by $14,200.
Thank you very much. Appreciate your arguments. And that case is submitted. Moving to item number 9, case number 370563, Ronald Packer versus Margene Tag. From tax to property. Yes, please. Whenever you're ready.
Good morning. My name is Michelle Kitch, and I represent the plaintiffs' appellants, Ronald and Robin Packer. I would like to reserve 5 minutes for rebuttal, if I may.
Okay.
I appreciate that you are familiar with the facts. As you may recall, this case is very complicated factually, and I believe legally too. And I wanted to I understood that you most likely had a good grasp of the facts, so I didn't want to take you down that road, which I'm not going to do. I'm going to just hit some of the high points I believe are implicated in this appeal. Number one, the whole ownership of the park. Trial court ruled that the 6 back lot owners that touched the park in a perpendicular manner, that touched Barlow Lake, somehow own fee without indicating to any of us at the trial how they acquired that fee and how it would be divvied up.
That's what I was wondering. Is it a collective ownership or he didn't specify that this person owned this part of it? And
Exactly. And to make it even worse, Your Honor, our expert Corey Hughes, who I understand is very well renowned and has been recognized in the Court of Appeals in various decisions as being a very reliable surveyor of not only land, but riparian survey. He took these theories that were advanced by the defendants and he prepared a couple of exhibits, which are part of the record. One was to show the court that there's no way to allocate fee in the park in the way that she ruled. She ruled that way at summary disposition and then said she needed some more information at the trial level. Mr. Hughes testified that according to his diagram, the only way to make account for an unencumbered fee would be in a plat vacation action. And the judge seemed to think that he was advancing this argument that it was only a street vacation case. Well, if you look at his exhibit of how he allocates on the unencumbered fee, it shows basically that everyone that abutted that park would own to the center, and the actual areas that would be owned by the defendants, if it was a plat vacation or a park vacation lawsuit, would not result in property touching the lake. That was ignored completely.
in fact, is there a road or there's a road, I guess, that doesn't cut through the park, but there's a road on either side, right?
Exactly. There's an access road. I think the plat said the parks, the drives and the alleys or whatever are dedicated to the use of the Arcana plat lot owners. So
based on published case law, you don't object to some semblance of ownership by properties abutting Park A, but the question is the scope of those fee rights.
well, I would say that, see, what happens is you've got, and my understanding is that the owners of all the properties around Park A, including the other plat lot owners, all 60 of them, have an access easement through that park. Nobody owns it, except for the folks that are adjacent to it. They own to the center, as would be shown on Mr. Hughes's diagram, which again doesn't create any lake frontage for those backlot owners, subject to the easement.
In fact, under that theory, and I think that's the theory, I remember years ago, we had Morse versus Colletti, which
Yes.
I think I authored. So, and I had to refresh on that case as well, but I think it held not as to a park, but a walkway between two lot owners
Right.
that they each owned in fee to the center.
That's right.
Subject to easement rights.
That's right.
And you're saying something similar here, but even then, the portion of the park that abuts the lake in this case, the only fee ownership would be plaintiff and the owner of lot 2 on the other side. of the
Exactly.
park. Is that
Exactly.
right?
And the trial court just ignored all that. I don't know why, but there is no, in our humble opinion, there is no basis to argue that they own fee. And to make matters worse, she even argued or ruled that my client, at first she said, anyone whose lot touches the park, that touches the lake, owns fee. And then Mr. Tripp pointed out to her when we had to go back to settle an order that, oh no, Your Honor, you made a mistake. And she said, you're right, I made a mistake. And said, I'm going to rule that the 6 backlot owners own fee, but lots 2 and 3 do not. Again, I don't understand the rationale for that.
So I'm just trying to understand the remedy you're requesting. So you don't take issue with the fact that plaintiffs and then non-party people who submitted an affidavit own a fee to Park A.
I,
To a portion.
yeah, as I mentioned, and maybe I haven't made myself clear, I'm sorry. Everyone who butts the parquet,
Including the people on like the peak of, if we think about the park as the shape of a house that an elementary kid would draw.
yes,
The
yes,
peak of the house, the lots on that side, you don't take issue with the fact that those individuals who own those properties also have a fee, question mark about the scope of that fee to the park.
well, as I mentioned, to the center, and most importantly, it's
But the
subject
to the center part, the court never held.
well, because she rejected Mr. Hughes's uncontroverted testimony. She said, oh, his testimony concerned what would happen if we vacated a road. That's not true. It's on the record. He said, this is what would happen if we vacated the park. And this is the only way that this is the only way in my discipline that you can account for an unencumbered fee. It would not give them riparian rights. Their properties would not touch Barlow Lake.
Do you think we need to figure out who has fee ownership in the park in order to resolve this case?
I don't think so, Your Honor, because I
Can you,
think that,
let's say we're just totally befuddled about who owns fee ownership in the park. What would you suggest we do with the rest of the case?
I would say that Your Honors would rule that the folks that no one owns the fee, except if there were a vacation, which were not there, but that all Arcana Crest flat lot owners owed an access easement by and through Park A to the lake.
Through the dedication.
That's what the
says. That.
Right.
Exactly.
So they have an easement to use the park.
Right.
And then the question is, what about the riparian rights to just put the part of the lake that's up against the park, not the rest of the lake, right?
Yeah.
And so if no one owns fee, but there's a easement to use, what does that mean for riparian rights? No one has them, or?
I would argue, Your Honor, that and I guess what you're referring to by riparian is the right to have boats and docks.
Yeah, so let's just be
Yeah.
clear. We're talking about boats
Yes.
and docks.
Right.
And we're talking about littoral rights, really, not
Right.
riparian.
Yeah. I was, yeah, it's a side story. That was actually
Permanent boats, right?
You're right, right.
Boats that stay there all year round or for a long time, and docks.
Right.
Who can do that? If anyone, maybe the answer is no one can do that. but-
As we've set forth in our brief, we believe that everyone who has a right to use Park A, that's all 60 lots, it's for access only. And the case law is very clear that what for the use of means no docks, no boats. That's uncontrovertible, I believe. Essentially,
Can you tell me which cases you rely on for that? Because I'm less convinced that the case law is uncontrovertible about for the use of meaning access only.
oh, I would refer you back to our brief. I mean,
There were a
Use
lot of good
several.
unpublished cases there.
Yeah.
Which I was reading, and I think they're helpful, even though they're not binding.
yeah,
But it seems to me at least some of those cases say that the word use, or that phrase,
right.
use of, is ambiguous. And because it's ambiguous, you go back and try to figure out what the intent of the dedicators was. And the intent of the dedicators may have been riparian rights or may not have been. And I can't remember which cases said that, but I think I read that possibility as well.
Well, Dolby, which does support our position, that had a situation where the actual platter had provided testimony. And that particular dedication was to the backlot owners for, I have to look at, it was a different dedication than was at issue here. But there, they said clearly, the backlot owners do not own fee in the park and stand for the proposition that any kind of an easement, be it a park, a beach, an alley, that is, parallel to the property that touches the lake, the folks that own up to that park own under and through to riparian rights. And I think Dolby is very consistent.
That's if, I know, but that's if there's fee ownership.
Of the front lot, yes.
Yeah. I'm
Yes,
talking about, that's universe one. I'm talking about like a different universe where there's no fee ownership or no one knows what the fee ownership is. And you're just talking about the easement. And what is the scope of the easement?
Yeah.
And I know a lot of easement scopes don't include riparian rights, but I think I read a couple of cases where they said, well, it's a question of fact. And you go back and you figure out what the platters intended. And if they intended riparian rights, then that's part of the easement. It's not part of fee ownership, it's part of the easement.
right. And there's no evidence that the platters in any way intended, in this case, I don't think anyone can cite any evidence that the platters, which are long since gone, intended to convey any right to take those usage rights, those access rights, and turn them into riparian rights. I believe that's a true statement, Your Honor. So in any event, I think it just becomes, the Packers don't have a problem with everyone in the plat being able to have an access to the lake through the park. And what does that mean? We believe the case law means that you can walk down there, you can use the water to swim, you can fish, you can erect a dock or a boat, and you can't leave anything permanently or overnight. You can have day use essentially. You can, because this is a park, you can come down and have a picnic. You can come down and maybe bring your kayak with you for day use. But that's not what happened here, Your Honor, Your Honors. They basically taken over the park. And I think it's, if I may continue, unless you have more questions on this
Well,
issue.
I think you would say they took over the lake part of the park, right?
Exactly.
You know,
Yeah, exactly.
the docking area.
Yeah, right, yeah, like 5 or 6 boats, 4 fingers. It changed from there's extensive evidence about how it's changed and when it changed and how it doesn't fit into the 15 years and all that. And, I'll leave that to Your Honors to, review that because it gets very factually specific. But essentially, the dock that is there now with the boats and all the apparatus was not there ever before 2018. Before 2018, there is some evidence that at one time it was a single dock. Then it became a 2-pronger, and then it became a 3-pronger, and then it became a 4-pronger. And then they added an extension, and then they took off that extension. And then it's back without the extension. And various folks had boats and docks there over the years. And we exhaustively, I believe, in our brief, go through the minute details of how, even if you accept the evidence that we have, it doesn't meet the 15-year continuous element of a prescriptive easement. Now I'm jumping into another area, but essentially I'd be happy to go through that.
Now we're talking about a completely different type of
Exactly.
easement, right?
Yeah, exactly. So we believe that, my client bought the house and property in 2011, I think, built their house in 2013 and noticed that this, we'll call it a marina, is right next door. And things are starting to get out of hand. People are putting boat lifts in.
They removed those though. Present day, there's no boat lifts, right?
I don't know, Your Honor, I don't know.
Oh, I thought it was in the briefing that it was removed.
That
I-
was,
I don't know.
the extension of the dock itself, making it longer, which we would say interferes with the continuity of element for prescriptive easement. The same situation did not exist for 15 years on an open, continuous, adverse, notorious basis for all the reasons set forth in it gets, as I said, gets very factually complicated, but I think every single minutia has been established by the Packers.
So
Yeah.
it seems like the easement is express, not prescriptive. We agree on that because it's in the plain language of the plat, right?
Well, the easement is a platted, dedicated easement, and that's what brings us to the Aston-Borsky decision that I think is very important. If I may go there, there are express deeded easements. We're not dealing with an express deeded easement. This is a platted, dedicated easement to all the folks that own lots in Arcana Crest. That's a very important distinction because of one of our arguments that would totally, if we are correct, and if this panel agrees, would obviate the need to go forward with any kind of prescriptive easement analysis. Now, why do I say that? Aston-Borsky was a Court of Appeals case. And in that case, we believe that the plaintiffs sued because they didn't like what was happening on their property, but that was a private deeded easement, not a dedicated or platted easement in that case. And in deciding the case, the Court of Appeals said, basically, quote, moreover, the cases cited by the plaintiffs, so those are the folks that don't want that the easement to be expanded by prescriptive easement, are not persuasive because they involve dedications of land as opposed to private easements, end quote. We see that as a recognition by the Court of Appeals, and it kind of makes sense to us that that's a good public policy. With a platted dedicated easement, that affects everyone in the plat, not just two parties that are next door and have an easement, maybe perhaps by way of a express deeded easement. So I think that, as we mentioned,
So you're saying that's a question of law, like you don't go through the 15-year analysis, you just say,
yes,
sorry, if there's a platted there's a platted easement, or if there's a platted dedicated
exactly.
easement, then there can be no prescription.
Right.
That kind of like it's a matter of law. Is that,
Right.
is that what you're saying
Right.
that case stands for?
Yes.
So let's say we agree that it's a platted dedicated easement. Why wouldn't we affirm the trial court's Little v. Kin analysis? Because the language of the platted dedicated easement is standing alone ambiguous. It just says use.
Well, again, I would argue, Your Honors, that the use of, I believe, for the reasons set forth in our brief, is not ambiguous, but if you find it, that's,
But that's relying on unpublished cases.
yeah, I think there are other cases, though. We brought, like Dobie. Dobie's a great example. Dobie is published, supports our position in that regard. But then again, the Little v. Kin analysis, I would just say, Your Honors, that the trial judge, in all due respect, ignored substantial material evidence regarding, number one, who owns the platted park? Number two, what are their rights with respect to the use of? Number three, the Estaborski decision. Number four, much evidence regarding the prescriptive easement issue, which I've raised in my briefs, but I would be happy to go through. And on Little v. Kin, essentially, this is a great example of where material, substantive, and substantial evidence was, for whatever reason, ignored. And that's why we look to this panel to recognize the injustices of that and to remedy that, if at all possible.
What about the Little v. Kin analysis was represents the trial court ignored material evidence?
Well, the whole continuity argument. She said that the 2018, she said that you could have a four-finger dot. Well, what about the analysis, if you go before that, that four-finger dot was not present for 15 plus years in the state that it was. I think it's really important, like the defendants will tell you, just ignore the fact that things changed. It doesn't matter. All you got to do is have some kind of a dock or boat there and voila, we win. I don't think that's what the case law says. It's got to be, again, open. Okay, it's there. It's got to be notorious, adverse, etc. Again, we cite there's no evidence of adversity. Matter of fact, I want to point out something.
This is, you're walking me through the prescriptive easement factors. I'm saying if we agree there's a platted dedicated easement, the language in that platted dedicated easement is use. We don't know what use means. We can look to some unpublished case law, but there's other unpublished case law that says a plat dedication is ambiguous because it does not identify the permitted uses of the park areas. That's a quote from an unpublished case from this court. So then we apply the Little v. Kin factors to help us understand the scope of use.
Right.
Where did the trial court go wrong in the application of Little v. Kin?
The precedent. And the reason this was not, I'm not saying that we can't answer your question, just saying that was not one of the before you get to Little V Kid, you got to find a justifiable reason for prescriptive easement, or you got to find a justifiable reason to get around Aston Borsky.
So Little V Ken only applies to prescriptive easements?
Well, I believe that's what happens, is that when you've established a prescriptive easement, you still have kind of a safety net that the court needs to weigh. Okay, you are overburdening that easement. You are overusing your easement. Okay, you've proved that 15 years plus, but here's a safety net for the aggrieved party. Let's weigh all of the the pros and cons and whatnot. And we did not, I'm not saying it was correct, but because the predicate to that is invalid, we didn't get to the Little V Kin.
I'm not
analysis.
convinced that Little V Ken only applies to prescriptive easement. I mean, there's some case law from this court that says it may never apply to prescriptive easement. And the language of Little 2 indicates it singularly applies to the determination of the scope of an express easement. Now, you differentiate a platted dedicated easement from an express easement, but I think as a matter of law, an express easement is something plainly granted to individuals by way of language. And here that language is for Arhanacross for the use of. The question is, what's the scope of that language? And my understanding is the only way to answer that without greater clarity from the plain language itself is to apply Little V Ken.
Okay, I think that, well, Your Honors, in all due respect, this was not something that was brief, so I am able to try my best to answer it. But honestly, I think that I would just say it's a predicate before you get to Little V Ken that there has to be some need to weigh the current overuse of an easement, be it deeded or be it platted.
Well, suppose we were to look back to, was it 1940? When was it?
41, I believe it was.
Okay. We were to look back at in 1941, we took a time machine back and we interviewed the dedicators and we said, what do you mean by use? Do you want to include riparian rights in that? And they said, nope, just picnics and sunbathing and, day boating and stuff like that. And so then we would know, theoretically, supposedly, right, what the scope of the express easement was. At that point, would we apply the Little V Ken analysis, or does that take the place of the Little V Ken analysis?
Well, I believe that, again, my understanding is Little V Ken only becomes relevant if there has in fact been a prescriptive easement or an overuse of an easement, maybe not a prescriptive, but an overuse of an easement. That's when you go to Little V Ken. But again, in all due respect, I understand, I'd be happy to answer your questions. I mean, no disrespect by this. But this, it was not in any event, I'll just leave it at that. Okay. Would you like me to continue or?
Yeah.
You have any more questions or anything? Okay, all right. I think it's important, again, to point out something regarding the ownership issue that I found was very curious. There was a clear contradiction by the trial court in her ruling as respects the factual findings for prescriptive easement in favor of each defendant. On the one hand, she ruled, and quote, these parties, referring to the defendants, have used this property in a manner that is no doubt that the owner's rights have been invaded. But then she ruled that the three applicable defendants are the owners of fee in that park. So hence, the trial court is effectively ruled, or has effectively ruled, that the defendant's use of their property created a prescriptive easement in their own property, in their own favor. And that is, I think that just kind of highlights so many of the intrinsic problems with the rulings in this case. They all kind of fall on each other, but they're not supported and they're not explained. And I think I'd like you to keep that in mind. She contradicted herself there.
So are you looking for us to affirm anything the trial court has done or just to fully vacate and say start anew?
What I would like, Your Honor, is on pages, we had for very specific requests at the very end of our brief, pages 46 to 47, we kind of outlined the relief requested. So I think that, and I'd be happy to run through that with you, but I think that the defendants do not have riparian rights to the park. They do own to the center, as indicated by Mr. Hughes, to the center of the park, subject to the access easement. Nobody has the right to put boats or docks there. The boats and docks that were put there have changed over the years. There were periods of time when there wasn't a boat there.
And that is your interpretation of the use of the word use,
Yes,
citing unpublished case law.
and Dobie and other, I'd have to go get my brief, but I know that there's published decisions like just that talk about, let me put it this way. My understanding is that the words "the use of" is not ambiguous and has been recognized to mean what I mentioned, and that is the right to get to the water, to use it as a park person would use it, to swim, to fish, to maybe bring a boat down for the day, but not to leave anything overnight, and specifically not to have boats and docks. I think even though I understand you're saying that it's all unpublished decisions, not all, as I mentioned, but a lot of them, those, I think there's a good amount of them, and I would hope that that would be persuasive.
So in order to have boats and docks, you need one of two things. Either the dedication needs to say that explicitly, or you need to have fee ownership because riparian rights come with the fee ownership.
If your property touches the water. Okay, so you have the case law is, there's published decision that only property that touches the water is granted by law riparian rights. Then it gets a little cloudy, because what happens when you've got like lot 17 in Dobie, you've got lot 17, and then you've got a parallel park, and then you've got the lake. And they were trying to argue that the park or the beach, what I think was a park, between lot 17 and the lake disrupted the riparian rights that lot 17 had. And the court said, no, they own, like in many cases, they own by and through a parallel type park or an alley or a walkway or, a street. They own under and through to the lake, and they're considered riparian because by execution of that type of a function, they touch the water. And that's what made it, I think, not correct in this case, that those 6 backlot owners, again, there's no way for them to own fee to the lake. But essentially, their properties do not touch Lake Barlow. And the park is not an intervening park, as other cases have had for alleys, beaches, whatever. So I think it's a misuse of Dobie, but Dobie, I believe, absolutely underscores that they do not own fee and that they do not have riparian rights to Barlow Lake. Hopefully that
So
answers.
as one quick follow-up, because your time is probably up. Before the trial, the court had a summary disposition ruling,
Right,
right?
right.
And in that ruling, the court didn't say anything about fee, but it did find, it granted summary disposition on the issue of what it called the ownership of riparian rights. So I'm wondering, what's your understanding of that ruling? Is it essentially a ruling that they own in fee, although she didn't mention fee? Or do the riparian rights, I think as you just said, only come from ownership and fee? Or did the trial court suggest that the rights came through the prescriptive easement or the dedication? Or what's your understanding of that ruling, I guess, which came before the trial, but I think the court reiterated it at the end of the trial?
Right. I think what happened is defense counsel suggested to the judge that those backlot owners were actually first tier or front lot owners. Defense counsel suggested that and the court adopted that. And then at first she said, well, if I rule your way, I will have to rule that all the properties that touch Park A have riparian rights because they touch the park and they touch the lake. Then it was suggested by Mr. Tripp, oh, Your Honor, I think you made a mistake. And this is all in the transcript, to which she said, you're right. I rule that all those six backlot owners, she didn't say they were first tier, but she said any property that only that touches the park is only, I'm sorry, excuse me, that only those properties that are only separated from the lake by the park have riparian rights. To which I argued, Your Honor, if you look at the configuration, those back 6 lots are not only separated by the park from the lake, but they're separated by each of their other properties, depending on where they fall, and also the street that is up against, comes up on both sides to the park. So you can't say that Dixie Schultz particular lot is separated only from the lake by the park. They're separated from other pieces of parcel. So that was a flaw, I felt.
Not to mention, it doesn't include the 2 lot owners who are adjacent to the part of the park that abuts the lake,
That's right,
right? Who apparently don't have riparian rights on the park.
Right.
According to that rule.
right. And so I tried to point out that there were issues with the reasoning for finding that they have riparian rights. And that was not satisfactory for the judge. So she declined to follow that. But I think that, yeah, there's just, I think if you look at it, it's crazy to assume that they're not front lot owners. They're not first tier. First tier are lots 2 and 3. And the others that are front. And there's reasons for that. They all pay less for their lots. And so I believe that, as I mentioned, the relief that we specifically set forth at the end of our brief, that's what I would be careful not to just say, I want it all thrown out, because there were some things that are not part of this appeal.
I think we understand, and I
Okay.
appreciate that. And why don't we hear from the other side, and
Thank
you'll
you.
have time for.
I have some rebuttal. Thank you.
Yes.
Thank you.
Good morning, Your Honors.
Morning.
David Tripp on behalf of the defendants, counter plaintiffs, Dixie Schultz, Margene Tagg, Linda Ainsworth, and Michael and Betsy Moore. I do take issue with the claim that my clients are not the first tier lots off the lake. There is something in between, and that's the park. Just like in the Dobie case, there was a park in between lot 17 and the lake. Also the same in Thies versus Howland, where there was a walkway in front of all of the lots. And the Michigan Supreme Court decided that those lots owned to the water's edge and therefore had the riparian rights. The only distinction I think that a plaintiff makes is that, in Dobie, it was parallel to the park was parallel to the lots. And in this case, in Arhenna Crest, they were at an angle. And I don't think there's a real distinction there. I think that my clients have the riparian rights because of the configuration, and there's nothing in between.
Can
Well-
you answer Judge Boonstra's question to opposing counsel, which was, well, I think the first part of the question is that conclusion from the motion for summary disposition stage of these proceedings?
Yeah.
Okay, and does that conclusion rest upon your clients and some others having fee to the park? And if yes, how do we know that if the trial court didn't say fee?
I don't know why the trial court didn't say fee, but that's our theory, is that they own the fee to the water. That's certainly what the court,
Because of Dobie?
pardon?
Because of Dobie?
Well,
I thought
Dobie-
Dobie kind of said the opposite.
I understand it was a little distinction, but that's because of Thies. Thies versus
Okay,
Howland.
so Thies involved, was it a road?
It was a walkway.
It was a walkway. Okay.
Right.
And I thought Dobie said, that's a walkway. This is a park. A park is different.
Understood, but they went on to go ahead and say that, well, lot 17 still has all of the riparian rights.
Yeah, so what I understood from that, I agree, I understood, it's sort of a coincidence because they went back and they checked, the people who own lot 17 were the successors in interest to the people who dedicated the whole thing to begin with. The old people who dedicated the whole, they owned the park. And because lot 17 was the successor in interest to the people who owned the park, they just happen to still get it, but not because of the riparian, not because not because of the water. They just happen to own the park because they were the successors in interest to the people who owned it before.
I understand that, but I think that was somewhat dicta. I think that if you go back and look at Thompson versus Enns, you can't sever the riparian rights from the land. So who owns the riparian rights in our Hannah Crest on those parks? I think it is logically the people who are off in the back where the park is in between.
So,
Why
so do
wouldn't
your,
that
your
have-
clients,
yeah.
I'm sorry.
No, you go.
Do your clients then collectively own the park together? Or do
No.
they each own a portion of it, and which portion of it?
So I think our expert said, based on his understanding of Dobie, that they owned individual strips of land to the water's edge.
Right, so you would essentially follow the lot lines? I mean,
Well,
if you follow the lot lines, you never get to the water from your client's.
well,
properties.
but normally in this situation, you like pie to the center of the lake, or you go directly to the lake. You don't go at the same angle.
Well, why, it seems to me that you would follow the lot lines to where they meet in the middle, which would only encompass the triangular part of the park to the, I don't know if it's the east, but to the, away from the lake. Why would it go that direction?
Well, because the road does not go through. And why their expert sort of stopped there and decided, oh, well, let's see, we'll give lots 2 and 3 the fee ownership. And that's not what happened in Dobie. I mean, Dobie did not do that. Dobie said the people behind the park, lot 17, had the riparian rights. They
That's
didn't.
because they were the successors in interest to the owners of the land who really did own the park in the past.
Right. I understand that, but
It was a coincidence. I mean, it was just happenstance that they happen to.
So let's say
this-
we disagree with you about the way you and the trial court have proposed slicing up this park. Okay, let's talk about the plain language of the plat, the platted dedicated easement, the express easement, what have you. I read the trial court as never finding that the plat language was enough to create an easement. It sounded like they only granted your clients prescriptive easement. Is that correct?
that they what?
That they only found a prescriptive easement. They didn't find it express in the plat language. Is that right?
Well, I think in the motion for summary disposition, she decided that they owned the lake and therefore the riparian rights.
But that didn't apply to all the defendants.
No, the Moores were given the right by Beckering, the owner of lot number 2, to use the riparian rights, which can be done.
That would be in front of the Beckering's property, right? Not in front of Park A.
Well, to the extent that, because Beckering owned not only lot 2, but also lot 60, which is in the same position as the Ainsworth, Dixie Schultz, and Margene Tagg. She owned one of the first tier lots off the lake also.
Well, she owned one of the back lots on the other side of the road that, yeah. I understand.
There's a road and there are back lots behind it. Moore's owned one of those.
Right.
But there's no road in between my client's property and the lake, the other 3, and Beckering.
Okay, so do you agree that the plain language of the plat affords Arhana Crest residents an easement to Park A?
That what?
Do you agree that the plain language of the plat dedication affords Arhana Crest residents an easement to Park A?
Yes. Yep.
Okay. Do you think the trial court found that the plain language of the plat dedication of Arhana Crest affords residence an easement? And if you do, where did that happen? Because the only discussion of easement I found by the trial court was with respect to prescriptive easement.
So I think that the trial court found that all the owners within the plat had an easement over the 4 parks to the lake. And they could have access in any of the 4 parks.
Where did that happen? Where did the trial court say that the plat language afforded them that? Because I find when I read the trial court's findings, and it's not the most clear because it was a little bit bifurcated with some findings happening at MSD and then trial, but I only find a discussion about a prescriptive easement and not any kind of express grant of an easement by way of the plat dedication language.
And maybe she didn't specifically address it, but I think that would have been the understanding that when the plat is dedicated to the plat owners, they all have a right to access to the lake over those areas.
Okay, and the plain language says for the use of. Is the scope of for the use of clear from that plain language?
I think part of the scope is for what all the owners can use, okay? But I think it's a little ambiguous as to what or who owns the riparian rights in front of the parks. And I think she decided that because they were the only owners off the park, that they therefore owned to the water's edge. Now, I think that she also determined that as a result of having the same dock configuration from 2005 to 2022, that they had acquired a prescriptive easement to continue those docks and continue the boats where they were.
So let me ask you this. It's only the individuals who surround in some way Park A that have riparian rights.
That's correct.
And it just so happens that those are the same families that have built and maintained and whatever this 4-fingered dock. Is that also correct?
That's correct.
Okay.
With the exception of the Moores, because they and their predecessors are backlot owners. They aren't the first tier of lots off the lake where the park's in between. But Ms. Beckering, who is in the same position.
Gave
as the other
hers,
3.
yeah. Okay, so let's say we disagree with respect to the fee. And we think the way the trial court sliced up the park was incorrect. And so those backlot owners don't actually go all the way to riparian. Is the language of the plat dedication easement enough to allow them to maintain a dock and a boat if it says for the use of?
I think it is, because I think the judge made those factual determinations that the configuration of the park and what was done not only by Dixie Schultz in utilizing the front lots and being told that she was entitled to a boat and a dock out there, and all of the other owners in the plat on the other parks use the parks for boats and docks. People in the same position that my clients are.
So are you applying the Little v. Kin factors to establish the scope when you look at that, or are you talking about prescriptive easement now?
I'm talking about the scope of the dedication. So.
And how do we determine that? We just look behaviorally, or is that where Little v. Kin comes in?
I think from a couple of different things. How the properties have been used over the years, starting in the 60s, and because we had testimony about that, and also because of the language and simply the configuration of this plat. It's very different than a lot of other plats. I've never seen one similar to this, and again, it was done in 41, and the idea, I think, was to funnel the people in my client's position into the lake and having the right to use the lakefront for boats and docks. And I think that the court, having weighed what and how things happened and what the configuration was, did properly determine that they have a right to use the riparian rights. And
Now,
again,
if that right derives from the dedication,
right,
that would mean that every lot owner in the entire subdivision has that right for all of the parks, right?
no. Well, the owners on the other parks in the same position as my clients would have those rights.
But I thought the dedication says that the use of the parks is dedicated to all of the
Right.
lot owners. That's collectively, right? So it doesn't say with, with the people who own lots near the park having more rights. It's kind of everyone has use of the park.
Right.
And
to
so
go
if
to and
use of
from.
the park means docks and mooring, doesn't that mean that it's not just the people who own lots near the park who have that, it's everybody in the entire subdivision?
Well, I think the distinction between those two is the configuration. And I think the judge decided based on the configuration and how people had treated this from as far back as we could find, is those in my client's position were the ones who used that, and it was designed to be used in that fashion, so that they, in addition to the rights to use the park, had the right to install the boats in the dock.
So
That sounds
use,
like a prescriptive easement argument.
Well, and I think there's a second part of that, and that's that they have a prescriptive easement at this point because of their use over
So
well
if
in
they have
advance.
no fee simple, just to reiterate Judge Kropkin's question, if we disagree that their fee in the park gives them riparian rights, and we think that the plain language of the plat dedication gives them an easement, but that plain language, what you're saying now is that plain language actually doesn't give everybody the right to moor boats and dock.
It's not specific. No.
So
They have the right.
so the word use of can mean different things for different people.
I think it could.
Well, I mean, is that?
Yeah, and I think that's what the court decided. Because of that in addition to the configuration of the plat. And again, I suppose they can be certainly arguments in the alternative. Either my clients have it as a result of the dedication and the court's determination that the intent of the plators was that they be able to have boats and docks. That's how it's been since the 60s. And then in the alternative, certainly my clients have shown that they have a prescriptive easement to use that area and to continue to use it. And the court went on in order to balance things out to say what could and couldn't be done, that they couldn't, no more boats or docks could be added, that the configuration there and the number of boats had to stay the same. Also made some other decisions with regards to what could happen in the park.
Are you aware of any cases that have addressed whether when you have a dedication that grants an easement, you can on top of that layer a prescriptive easement? Or can you only have one or the other?
Well, in my brief, I pointed out Beach versus Lima Township, that case. And that was adverse possession of roads within a plat. So even though it was dedicated to the use of the lot owners, the roads, that they were able to, by adverse possession, claim title to those roads. And I think similarly, the same can be done with adverse possession that despite what the plat dedication says, my clients can still acquire a prescriptive easement. And again, the Aston-Borsky case is distinguishable because what that dealt with was a specific written agreement, and it wasn't a plat at all. So I don't think that's that controls this matter. The other interesting thing in two of the cases that, and again, they're unpublished cases, but there were two cases that dealt with a beach, which is similar in nature, I think, to a park. I mean, the idea behind it is that multiple people can use that. In both those cases, the Sullivan case and the Wojcik case, the court determined that the owners of the lots that were immediately adjacent to the beach, with only the beach between them and the lake. And again, I think they were quite deep. They found that they had the riparian rights to the water, that the fact that there was a beach in between dedicated to the use of the plat owners didn't change the fact that they, as sort of the first tier lot off the lake, had the right to use or had the riparian rights. And again, my question is, so what's happened to the riparian rights? Who owns those at this point?
What case was that you were just referring to?
The Sullivan case and the Wojcik case.
The beach one?
Yeah, they're both beach ones.
Okay. And were those before or after Dobie? I guess that's a tough question to put you on the spot. But that's what's going on in my mind.
Yeah,
you know?
I think they were after.
Okay.
Wojcik was 2011. And Sullivan was 2009.
Okay.
But again, an interesting point in Wojcik was that they determined that because the owners of the lots adjacent to the beach had worked on and made the beach, I guess, more pleasant to everyone, that their idea and their interpretation was that it was that they had the riparian rights partly because the plators had intended that someone take care of the beach. Certainly in this case, had the plators wanted everyone to control the beach and handle the beach, and they could have done an association and required everybody to be a member and required them to tend to the beach. Whereas here, it's my clients who have taken the initiative to make that a viable beach by putting sand in and doing constant maintenance.
So it sounds like, barring us finding that the fee simple includes riparian rights, the only way to maintain status quo is for us to find a prescriptive easement. Because what you're saying is the plain language of the plat dedication does not afford every resident of Arhana Crest the ability to moor and dock and build.
Right.
And you're saying that citing what? Is just, does everybody understand that the use of does not include mooring or docking?
Well, the use of, yes.
Yeah.
Yes.
Everyone
And that goes back to fees. And that's what they decided, that the backlot owners couldn't moor their boats and put docks out in front of the other people's lots where the walkway went in between. But I think the distinction here is it's a park. It's like the beach in the Wojcik and the Sullivan cases. And so it should be treated differently. Again, Dobie did treat those differently. Again, I understand some of that language, but I don't think that, I still think the result was correct, because who else owned the rights to the water? And again, what's happened to the riparian rights on that beach? They can't be severed. And again, Dobie, they did not give the two adjacent front lot owners divide the park in half. They said it belonged to the people who had the first lot off the park. And I think that's what I think should happen here. My clients are the first lots off the park. So,
All right. Any further questions? Anything else you'd like to add?
no, that's fine.
All right. Thank you very much. Appreciate that. Ms. Kitch, any rebuttal?
Yeah, just briefly, Your Honor. I did find the cases that support the use of means, no docks or boats. And those were cited, the Dobie case, Morse versus Coletti, Thies versus Howland, and 2000 Baum Family Trust versus Babel. Also, it's interesting, the irony of the situation. We have a dedication that the alleys or the parks and the whatever the dedication is in this case, which it includes the parks, are dedicated for the use of all Arcata lot members only. But Mr. Tripp wants to argue, well, that applies only to us, not to.
I think he argues that, well, you've got a prescriptive easement on top of that.
Right.
Well, actually, he argues they've got ownership and fee first.
Right. And so I don't think you could have it both ways. I mean, either everybody has a right to have boats and docks there pursuant to the dedication, or they don't. And if they don't, what does that mean? It means that nobody does. And I think that's consistent with the case law and the interpretation, unpublished and published. But I think it's also, I just think that's ironic that it doesn't apply to us. And I don't think in any way you could argue that these folks are first tier for the reasons set forth in the brief. I think that's all I have now, unless you have some questions.
Let me ask you the same question I asked Mr. Tripp, and I think you may have mentioned a case earlier, but I want to make sure I get
Sure.
it. Are you aware of cases that have decided when you have a dedication and an easement that flows from that, whether you can have a prescriptive easement on top of that?
I would argue the Astroborsky case that for public policy reasons that we're urging the court to take a deep dive into that issue, because it would help practitioners like myself and others know what the law is on that, because we constantly are arguing our interpretation of Astroborsky, and we think, and we're glad that we're able to get it out in front of the panel and it really take a deep dive, because the cases cited, we put that in our brief, all specifically talk about are all the ones that were not found to be persuasive because they dealt with platted dedicated easements were all cited in our brief. And we could show each and every one was a platted dedicated easement, not an express easement, which was involved in Astroborsky. So we interpret the language of that decision to say you cannot get a prescriptive easement on a platted dedicated easement unless, I would argue, everyone in the plat is agrees to it or is subject to some type of a adjudication on that issue. Here, everyone even Mr. Tripp agrees, everyone here in Arcata Crest had a right to at least use Park A, Park B. We're not talking about the other parks now, but Park A. And so they have usage rights that nobody can take away. And what the defendants are doing is trying to take away their usage rights, interfering with their usage rights. Nobody, contrary to what they say, there's no room for another boat there. There's no room for launching. There's no room for as my clients testified, fishing or swimming. They have very special damages. We haven't talked about zoning, but in any event, it's all in the brief. I think compelling reasons for zoning ordinance violations. Can't walk on the beach because there's clutter everywhere. Can't see out into the beautiful lake because the boat lifts block their view. So I think, you know, it's a very severe thing that I believe the defendants have done here, trying to sneak in through a alleged prescriptive easement when they cannot show the 15 years continuous, you know, adverse, without permission, et cetera. I mean, there's a lot of deep diving on the prescriptive easement, and I tried to provide it in our brief. And if you have any issues with it, I kindly request that you look at that because I don't want to take up your time now getting into the minutia. But I think that overall, it does establish that they, even if you can get one through prescription through a platted dedicated deed, not deed, platted dedicated easement, they haven't done it. And so I think that the rulings fail for a lot of reasons, as I've set forth in our brief, and we would just ask that the court grant the relief requested at the end of our briefs.
All right. Thank you very much. Thank you both.
Thank you.
Appreciate your arguments. Very helpful and a very interesting case. And
Yes.
we will study it further in light of your arguments and issue a decision as soon as we can.
Thank you.
All right. Thank you. Case is submitted. All right, moving on to item number 10, case number 377-638, In re Garnett Couch Minors. We have one party endorsed for arguments. You may proceed. Oh, we have two people here, however. And just tell us who you are.
Melissa Calais, may it please the court. I represent Mother Respondent Jaquila Couch, who's here present in the courtroom. I did file a motion to request that I can present oral argument that was denied, but the motion did indicate I could answer any questions the panel has. So I'm happy to answer now or any after.
Any
appellate
questions for
response.
Ms. Calais?
I do not. Thank you.
Thank you very much.
Good morning, Your Honors. Audra Blodgett on behalf of the Kent County Prosecutor's Office. The only issue on appeal is whether termination was in the best interests of the children. I believe both of our briefs lay out the relevant facts and procedural history. I have nothing to add, but would be happy to answer any questions.
Questions? I have none either. Thank you for
Thank
being
you.
here. Thank you both for being here. And case is submitted. Item number 11, case number 378-697, In re Treffel Wiggins Minors. We have one party not endorsed, but appearing remotely for any questions the panel may.
Can you give me just a minute? I might have a question.
Yep, take your time.
Good afternoon, Your Honors. Jordan Ealer Smith on behalf of the respondent mother. As you indicated, Judge Boonstra, I am not endorsed for argument, but I am happy to answer any questions that Your Honors have for me.
Well, give us just a moment, if you would.
Was this the one with the grandfather? Is there a grandfather involved in this case?
Yes, the paternal grandfather was the placement and part of our argument. Yes.
Okay, here's my question. I was a little unclear, and maybe this is more for the appellee who's not here, but I was a little unclear on actually appellee is here, right? Yes. Okay. Well, let me ask you first, Ms. Uller Smith. There was some discussion on the record about the grandfather, maybe they're being concerned about how long the grandfather could care for the child. Is that right? Because when it comes to this guardianship question, I'm just trying to piece together what was going on in terms of the grandfather's ability to care for the child for more than just this, the foster care placement.
So I don't recall exactly from the record, Your Honor. And again, I know that Ms. Calais is in the courtroom and maybe she would have a better answer for that. But what I will say is that there's not much information in the record about whether there was any consideration or even a discussion with the grandfather about whether guardianship was an option, which is maybe why I'm not recalling there being much in the record about his ability to care, just because there wasn't that discussion that was had. But as far as my recollection, I'm not recalling that from the record, Your Honor. But like I said, Miss Clay might be able to answer that more effectively.
I mean, it just seems to me that if guardianship is out in the universe as a possibility, but the potential guardian is not someone who's in a position to take on a long-term responsibility due to health issues or otherwise, that presents a different scenario than one where, the guardianship is just rejected out of hand. So I was just seeing if we could get to the bottom of it, but maybe that's going to be hard on the current record. So.
Okay. Anything further? Ms. Clay, why don't you come up? I know you're not endorsed, but since my colleague to my left here clearly has a question for you, I'm going to exercise my discretion to let you ask and answer again.
Thank you, Judge Winstra. Same question, if you know.
Sure, I'll just place my appearance on the record. Good afternoon, Your Honors, Melissa Clay, on behalf of Montcalm County DHHS. And I'm sorry, Your Honor, I do not have a clear answer either from the record, and I'm not sure how much of that is my memory of the record versus if there was really a gap in the record. I would just really say in response to that I do think that the published decision by this court of Enrique D. Simpson is very clear on this, the explicit language. I was one of the appellate attorneys in that case. I'm very familiar with that case. Explicit language by this court was that there needed to be a filing of a guardianship, like a guardianship petition filed with the court. I know that this court takes very broadly the idea that even if something is not raised in the trial court, that lack of preservation, the issue doesn't bar a respondent parent from raising that issue with this court. But I think with the guardianship cases, they're a little bit different. It's almost, in my mind, a little bit of an invited error analysis. It's hard to say that the trial court erred by not awarding guardianship when nobody said, hey, I would like a guardianship. So I just think that analysis is a little bit different than what we typically see in these cases where the issue is, did DHHS provide enough services to a parent before terminating parental rights? So that would be my response here.
Thank you.
All right, thank you. Any further questions for Ms. Clay? Any further questions for Ms. Jordan Ayler Smith?
Thank you, Your Honor.
See none. Thank you both for being here in person and remotely.
Thank you, Your Honors.
Case is submitted. Item 12, case number 375267, in re Pasiga minor, is submitted on the briefs. Which brings us to the final item of today's case call. Item 13, consolidated cases 376693 and 376694, People versus Stevie Anthony Woodard. No one is here on that case either. Those cases are submitted on the briefs. And that concludes our case call for today.